Care home fees are a real concern for a lot of people. You'll probably have worked hard to pay off your mortgage and accrue savings, and to have those jeopardised by needing to go into care at any time in the future is a real unsettling and upsetting thought that your loved ones may end up inheriting little or nothing from your estate. If you need local authority care and have assets of over £23,250, then you run the risk of having to fund your own care, even if you have to sell the family home to do so. Most couples own their homes jointly. This means that if one were to pass away, the survivor owns 100% of the property. This leaves the survivor in a vulnerable position should they ever need means testing. By making some simple changes to the way we structure your will, and in particular dealing with the family home, which is quite often the main asset, we can make sure that when something happens to one of you, your share passes into your trust basket rather than passing directly to your spouse or partner. The reason that's an advantage in planning for care home fees is it's often when there's a sole surviving person living in a property that the house would be taken into account for means testing purposes. By ensuring that the property is split into tenants in common, and on the first person to pass away, their 50% goes into their respective trust, the survivor is then only deemed to own 50% of their property rather than 100%.